Our first panel at this year's Qui Tam conference on February 27th and 28th is the Year in Review. And moderating the panel is John Thomas, who is with us today. John, you have started a new firm, right, in Roanoke. Tell us a little bit about the firm.
Absolutely, yeah. I've joined up with a couple of Marines that I served with, John Hafemann and Brian Magee. Our firm is Hafemann Magee Thomas. John and Brian are in Savannah, and I'm in Roanoke. And I focus on Qui Tam. We also do some federal criminal litigation, federal civil litigation. So it's been fun.
Terrific. Tell us a little about the panel. It's our first panel, Year in Review, on the first day of the annual conference. If I'm in the audience, what can I expect?
Well, this is, I guess, the third year we've done the Year in Review panel, and I think what we've tried to do is provide a panel at the very start of the day when we can kind of look at the past year in sort of a broad, big picture way. A lot of the other panels will obviously drill into some of the specific areas with a lot of detail, but I think there's value, particularly as we get started for the day, to really look at what are some of the broader patterns that we can see in the Qui Tam practice over the past year.
And who do we have on our panel?
So this year we're very fortunate to have two returning panel members. We have Claire Sylvia and Stuart Dellery, both of whom obviously need no introduction. Claire authors probably one of the most important treatises out there. She's with Phillips and Cohen. Stuart Dellery obviously served as Associate Attorney General under President Obama. And we're also very excited to have Tajinder Singh join us this year as well, and he focuses on appellate practice within the False Claims Act. And he was on another panel last year, and everybody really enjoyed, I think, his perspective, and we're really excited to have him this year.
So give us a sense. I mean, we now, a few years after Escobar, we have 2 years after the Brand memo. Kind of what are some of the big issues that are percolating out there that you might touch on in the panel?
Well, I think you're exactly right about Escobar and materiality. We're still continuing to see district courts and at the circuit court level Escobar applied. So we're still seeing sort of the after effects. I think we have another panel on AseraCare, but we see that especially in the medical necessity arena. I think that's an important area we'll talk a little bit about. But we'll also, I think, talk a bit about the Granston memo and what we've seen in terms of some of the different circuit courts on the government's ability to dismiss Qui Tam actions. We obviously have two different standards that are out there, and I think it'll be interesting to hear our panelists' perspective on where that is heading between the SWIFT standard, the Sequoia standard. I think another important decision this year that we'll spend a little bit of time talking about is the Conscience consultancy case, which of course dealt with the statute of limitations for relators, and I think that is a pretty interesting and important development over this past year. So I think those are a couple of the big wave tops, but I think we'll also be looking at other notable settlements for the year, as well as some of the other policy coming out of DOJ.
Now, you were involved in a big case this year against Duke University, and it dealt with grant fraud. Tell us a little bit about the case and just a little bit about maybe some lessons learned.
Absolutely. So the Duke University case was, I think, a pretty important case this past year, dealing with fabricated or falsified data in grant applications, in NIH grant applications. It dealt with a particular laboratory within Duke University where fabricated, falsified data appeared in a number of grant applications over the course of years. And I think it's an important case for a couple of reasons. One was its size. Although we've seen the NIH deal with, and of course the Department of Justice working with the NIH, we've seen them deal with grant fraud in the past, but not on this scale. And I think that was important. I think it's also important post Escobar to have had a case dealing with the materiality aspects of scientific data in grant applications, and shining a light on what is important for the government in terms of these funding decisions.
John, thank you.
Thank you.
We look forward to seeing you on February 27th and 28th here in Washington for the Qui Tam Conference. You can find us at fedbar.org.